Welcome back again. I'll keep sharing. If you go to all the social media handles, you can find Four Stars TV and subscribe and also share Four Stars. We here we do because everything is on the internet right now, the World Wide Web. This is how we also spread all the good news. If you can see the picture on the screen, let me invite one and only Dr. Edu. Doctor, welcome. Lawyer. Lawyer, do welcome. Can you
Yes,
hear
sir.
me?
Thank you, sir.
Oh,
Yes, I can
okay.
hear you.
Oh, okay, okay. Thank you so much. We know back home, ladies, we're talking to Dr. Edu, who is in Ghana. We all know Ghana this time is very late on the weekend, but he has taken the time to talk to us a little bit about the inside of AGRADAA's release. Doctor, have you heard about AGRADAA's sentence being reduced to a year,
Yes.
from 15 to a
Thank you
year?
so much, and your listeners and viewers. So I've had the benefit of the judgment
Okay.
of the court, that's the High Court in Amasaman, that has reduced the sentence of Patricia. Is it Apiaje? I don't know the full name, but Mami Agrada, as we affectionately calls her. So yes, I've seen the judgment, and then I've seen the consequential orders that were given in those in that judgment.
Oh, okay. Now, on what grounds? On what grounds can a 15-year sentence be reduced to just a year?
Very well. So I would have to situate this in perspective. Normally, when you have a criminal matter, you are tried under a particular law. So in this particular situation, the woman was tried under Act 29. Act 29 is the Criminal Offences Act. And particularly, we are interested in Section 131 of Act 29. So you go through the normal trial where a judge will listen to evidence from prosecution regarding what you have been charged with. So she was charged with defrauding by false pretenses and other offenses which are minor. They are misdemeanors. But the serious offense in her particular situation was an offense that is called defrauding by false pretense, contrary to Section 131 of the Criminal Offences Act 1960, that's Act 29. That law says that anybody who by a certain misrepresentation or any information convinces someone to part with or takes something that belongs to the person and not doing what he is expected to do has committed an offense. And that offense is classified as second degree felony. By second degree felony, you go to subsection 2 of Act section 131 of Act 29, and you realize that there's another offense that is created under that subsection, that defraud someone by using the name of the president, a minister of state, or a government person to deceive someone
Hello.
or whoever that you are misrepresenting to be. That one, you commit a second degree felony, and then there's a specific sentence which says that you are supposed to go in between 10 to 25 years in prison. That is if you are found guilty of that offense. So Agrada's charge was in relation to 31. That is section 131 of Act 29. And that one does not give a specific sentence. If you want to understand the sentencing regime in our Criminal Offences Act, you have to go to another law. That law is called the Criminal Offences Procedure Act, Act 30, 1960. That law will give you the procedure through which someone is taken through a criminal trial, and then specifies the sentence regime for offenses that the law has not been specific with the punishment regime, that is the sentencing. So in this particular case, you go to section 296 of Act 30. That is where you find the sentencing regime. And that section says that if someone commits an offense and the person is convicted after trial and is convicted as having committed the offense, and you are going to sentence that person, you refer to section 296, which talks about second degree felony, and says that the person who is convicted of second degree felony can go to prison from 1 day to 25 years. So the maximum sentence is 25, but it doesn't give a minimum sentence. So then it's assumed and inferred that the minimum is a day and then the maximum is 25. So depending on the gravity of the offense that has been committed, a trial judge, that is the court of first instance, where the person was taken to first for the prosecution to give their evidence and then take witnesses, and then they get cross-examined by the lawyer for the accused person, and you are convicted, the judge will consider the totality of the evidence and the fact that you are someone that has committed an offense before and been convicted. That is, you are known to the law. That is, if you are an ex-convict, the judge will consider all those factors and they make a determination as to the number of years. That is at the discretion of the judge. The judge would have that authority to choose based on all the mitigation that will go on. So the lawyers are given the opportunity to mitigate the offense. So then you have to speak to the fact that the person is a pastor, the person is running a church, the family person is a responsible person, the person is a family person, and all of that. You will get the lawyers trying to convince the court that this person is not someone that is that bad. And so when you are punishing this person, take into consideration her conduct, her attitude, and everything, so that you don't end up over punishing the person. But since it's at the discretion of the court, then the prosecution also give reasons why this person should go into prison and this person should be given a very stringent punishment so that tomorrow the person does not go and commit that offense again. And then it serves as a deterrent to other people who may want to use that same avenues to commit an offense. When that is done, then the judge takes a decision. So this is what happened at the circuit court. The judge says that after listening to all the evidence, I believe that you have committed the offense as it has been proven beyond reasonable doubt. And so go to prison for 15 years. So out of the 25 years, the trial judge at the circuit court in Accra decided to give Mami AGRADAA 15 years. And so when you are sentenced after your conviction, the law gives you the right of appeal. For purposes of education, when the matter happens at a district court or a circuit court, the forum for appeal is the high court. So in this situation, the high court then becomes an appellate court that can listen to the appeal of the person. So they appeal to the effect that with all of this that has happened, it was selective justice, and that the judge had an interest and decided to punish the woman based on things that he might have heard out of the courtroom and not necessarily from the evidence that were produced by the prosecution. So for that reason, the sentence should be passed. But the High Court judge, who is an appellate judge in this particular situation, decided that, look, I've gone through everything that happened, and what the court did at the circuit court, which is the court of first instance, was proper, was within the law. So her conviction will stand. But that notwithstanding, the sentence is too harsh, depending on the amount that is involved and the people that are involved. So he rather decided to reduce the sentence from 10 years to 1 year. And don't forget that I've already stated that within Act 30, the punishment regime is specified. And in this particular case, is between 1 day in prison to 25 years in prison. Because the law lies in the bosom of the judge and the judge has a discretion to exercise. I don't know the arguments that went into the court to the judge to be satisfied to the effect that this woman is now remorseful. She's someone that might have changed, and looking at her demeanor and her conduct in prison, she's someone that is reformed. For which reason, the judge can take a decision to reduce the sentence. That one is at the discretion of the judge based on all the evidence that will be given in terms of the submission by the lawyers for the accused person who is now appealing the conviction. When that is done and the judge reduces the sentence, he can also choose to even increase the sentence. So it could have been a situation where the judge will say that, look, your sentence is even lower. Go in for, let's say, the maximum 25 years, or I'll even increase it to 20 years. But I think they consider the fact that the people are also going to be compensated. You know, there were some complainants that said they parted with about 1,000 Ghana cedis, expecting a double or multiples of that amount. It was based on that advert that they went to the church for that particular online. So the first offense is the fact that she advertised that I'm going to share money. And if you advertise that you are going to share money and you fail to share the money, it means that you want to deceive the people. Now it's been proven that yes, you didn't share any money. You rather put lights off, you threatened the people, you intended to even beat them up for them to run away. Now, if you are given the opportunity, I'm giving orders for you to compensate these people with an amount of money. So I think all the people receive their 1,000 cedis as refund, because in criminal matters, it is not used to recover your debt for you. It is rather to punish for someone's offenses based on infractions of the law. So when you are given that opportunity and you compensate those people, then it also goes into the mitigation, which can reduce your sentence. So within the discretion of the judge, the sentence was then reduced from 15 years to 12 months. So it means after 12 months, which probably will be in some few months to come, the woman will be working free.
Wow. Wow. Hey, we are talking to lawyer Du Dakonwe Squad, PC for Santia Chem Central, and he's explaining the whole detail because everybody was shocked and was stunned about this reduction. But lawyer, could this decision weaken the deterrence against the financial crimes in Ghana in the future? And then, based on what you just said, how is this 12 months being calculated? So, is it calculated from now to December or to October? I know the sentencing terms is a little different from the way we understand our terms. So, if you want to explain that into details for us.
Okay, so when a court gives you a sentence and specifies a certain number of years, the prison terms is about 10 months. It's a little over 9 months. So
Oh,
it's
okay.
about, let's say, 10 months. That is, if they say you are going for 1 year, the prison term is reduced for you with some few days in a year, making it about 9.5 to 10 months. So tentatively, then the number of months that you have. But in this particular situation, the judge says that it has been reduced to 12 months. So if he says 12 months, 12 months is 12 months. But if he says 1 year, then we are talking about 1 year prison term. And the calculation will start from the day you went to prison, the first day you went to prison. So it means that she has already exhausted. I think she went in somewhere around July or something. So she has already exhausted about 7 or 8 months. So she would have just about 4 months to come. But if it was in years and say the judge says that I've reduced it to 1 year, then you are going to calculate about 10 months. So that will be somewhere around April, May thereabout.
Oh, okay. Some Ghanaians believe political or external influence played a role in the legalities speaking. So, legally speaking, how do we assess such claim that it is an outside influence or political, kind of backlash or something that made this decision came around? How do you respond to that?
That can only be a suspicion, because once the judge works within the parameters of the law, I always tell people that until you find yourself at the wrong side of the law, you may not know how the law can favor you. So when you find yourself at the wrong side of the law, look for a good lawyer who will be able to explore other avenues where the law can help you. Because as we say, the law is an ass. It cuts both sides. So front and back, it cuts. So the law that can punish can also exonerate. It can mitigate. The law is not supposed to punish you to the extent that you become worse off. So if genuinely this person has changed and there's a certain remorsefulness in her actions and attitude, then a judge may look at all those factors, inquire about them, and then make a determination and say that for your conduct, I have decided to reduce your sentence because I'm working within the parameters of the law. The judge cannot do that so moto without any support of the law. So it's the law that backs the judge to take that decision. So they looked at the operation of the law and the position of the law and how it can help them. And that's what they explored. So they explored the option of the law assisting them for her to come out, and it worked out for them. It could have been worse. So if they played their cards well and it worked, then we can only commend the lawyer and especially the husband who was all over the place trying to seek all avenues possible to ensure that the wife comes out. As to what happened behind the scenes, you and I will not be in a position to be able to verify whether indeed there was some influence. But to the extent that it doesn't flout the law and is within the parameters of the law, then the judge cannot be faulted, the court cannot be faulted, you cannot fault the lawyer or any other person that took advantage of the law.
Okay. So, what safeguard exists to prevent abuse of discretion by the judges or authorities? What safeguard? Because sometimes, like you make mention earlier on, sometimes the person, from the judge's own discretion can say, I just look at you as something. So, take this year from the initial sentence to that 15 years and then from what we are saying right now. That's what I'm asking. What safeguard exists to prevent abuse of discretions of such a nature?
So the Chief Justice has a supervisory role to play when it comes to the work of the judiciary. And if anybody suspects or believes that the reduction of the sentence is unjust, then there is the right of appeal. So at the level of the Attorney General, when a conviction is set aside or is more or less there is a sentence reduced or anything that has got to do with the judgment and you are dissatisfied, they can also go for a further appeal at the Court of Appeal. If AGRADAA feels that what happens at the Court of Appeal, let's say they go to Court of Appeal and the Court of Appeal says that, look, the 1 year is too small, so go for, let's say, 20 years or the 15 years should stand. AGRADAA can also go to the Supreme Court for a final determination. So the right of appeal is there. So anybody that feels disgruntled or feels that you have not been treated fairly or suspect an abuse can get the AG to pursue an appeal of the decision of the High Court, which is an appellate court in this particular situation. After that, you can go to the highest level. But if there's a suspicion that some connivance or some corruption might have taken place, that one you have to make a formal complaint against the judge before the Judicial Council, so that the Chief Justice will set up a committee as stipulated by law to investigate the conduct of the judge. So until you have some evidence to prove that, look, something might have gone wrong, it is very difficult to then make such assertions to the effect that the judge might have been influenced or the judicial system might have been influenced. I feel they considered the position of the law and then they took advantage of the fact that you can appeal, you can win the appeal, or you can get a reduction. So let's try this. They tried and it has worked for them. But if there's any suspicion whatsoever that we believe that this action or this decision might undermine the authority and the confidence that we have in our judicial system, then a complaint can be lodged at the appropriate quarters and then an investigation conducted so that they take it from there. So those are the two remedies available. Either you go on appeal. So the complainants in this case, if they are dissatisfied, can get the AG to go on appeal. Or if they feel that there is something that has gone on and they suspect some corruption of any sort, then they can also address the Chief Justice on that and then seek for investigations into the conduct of whoever they suspect. And then when the person is found culpable, that person can even lose the position. You remember the Anas situation where it was established some years back that some judges were influenced by all manner of things, including votes. Then they were put before court, and most of them lost their jobs because of the corruption that was sort of proving. So it is just a duty on the part of whoever suspects something might have gone on to take it up. But as far as it stands now, the judge worked within the parameters of the law, And it will be very difficult to prove anything like that, in as much as people may have that suspicion.
Okay. Okay, good enough, lawyer. Thank you so much. Now, because of some of these things makes a lot of us have a double mind or double standard in our judicial system. A lot of people don't really believe in our judicial system, but I think those of you who are in the forefront, that you go to the courts and everything, you can see that it really works. Now, how does this such a sharp reduction affect the public confidence in the justice system? Because a lot of people have asked you already, but let me just couple this with this question again. Then how does such a sharp reduction, because it was just out of the blue and nobody knows, they went to the appeal court. Where did they go? Is it an appeal court or where for
So
this
where they
to
went, where they
yeah,
went is the High Court.
okay,
So the High Court has different jurisdictions. Aside the fact that they can entertain cases from scratch, they also have an appellate jurisdiction. That means that cases at the Circuit Court, which is lower, and cases at the High Court, if there is any sentencing in a criminal matter and you are not satisfied, you can High Court for an appeal. And because Agrada was in Sawam, the closest, I believe, appellate court is the Amasaman High Court, for which reason they went to the Amasaman High Court to get the sentencing reduced. So, yes, it's the High Court. But talking about confidence, I think the problem is not entirely about the confidence. The problem is multifaceted. First one is the fact that we lack a lot of legal education in terms of our understanding of the law. It's quite unfortunate that people look at just aspects of the law, a narrative, and then they believe that that should be what it is. But the law is quite comprehensive and broad, and it comes with a lot of technicalities. I believe as a people, it's just now that we have even opened up the law school and the other legislations, making sure that the monopoly within the law school is taken away so that other law faculties will be able to train a lot more lawyers. I think what we lack is the education. So that's how come for some of us we accept such invitations to speak about issues relating to the law. So because we lack the education, we are unable to appreciate the multifaceted nature and the way and manner the law operates, and it makes us lose a lot of confidence. I believe we are having a lot of education. We will then appreciate that, okay, when you do A, B, C, D, these are the rights and these are the privileges and these are the opportunities available to you. Because the Constitution, pursuant to Article 19(2)(c), says that everybody who has been charged with any form of offense is innocent until you are proven guilty. And that has been reiterated in a very common case that referred to my learned senior Martin Pebu versus the Attorney General. That even makes every offense, including murder, bailable. So, as the law evolves, we also have a duty to educate people about the various aspects of the law and how you can take advantage of the same law that can punish you. So the perception partly is to be blamed for the lack of education and appreciation of the law. Because I remember this appeal started right from the very moment the sentence was done. And I think the lawyer that was handling it, one of them even died for another lawyer to continue from there. So it's been ongoing for a while. But you see, the media rather reports what is the finality of the matter, because that's what makes the news. But if they had taken their time to take people through the period where the appeal started and where we had got into, then people will appreciate the dynamics of the particular case and how it has turned out. So yes, the perception is there because we lack a clear understanding of most of the things that happens, and a lot of people also apply their emotions. It doesn't look too good if someone that was sentenced for 15 years is drastically reduced to a year. But my brother, I also tell you that prison is the last place you expect even your worst enemy to go. So there are people who genuinely get reformed. And then there are people who commit very petty offenses. And they will be in prison for so many years and not get any support. The truth of the matter is that there's a certain class disparity between the upper class and the lower class, where people are unable to afford legal services, because then those people that went to steal cassava and fowl and those things, if they are to get the resources to engage lawyers to also fight for them, they will make use of the law to get them exonerated or their sentences reduced. Some of them don't even go through trial. They are just on remand about them, and that's the end of the story. Until there's a special policy or something to get the prison decongested, these people will be languishing in jail when they have not even been tried and then be convicted by a court of competent jurisdiction. So I think the challenge is with one, representation. And it's not as if there isn't enough lawyers. Yes, now we are producing a lot more lawyers. I think about 800 or so passed out just last October, and a lot more will be passing out in the coming years. Now, the problem is affordability. How many people are able to afford the services of lawyers, to be able to pay for them, to represent them the way Agrada's husband in Siama was all over the place, engaging lawyers left, right, center, and making all the necessary payments he has to make in terms of maybe filing of documents and following up on the cases. I remember there was even another matter with Empress Gifty that he went to an extra mile to try and even settle those matters. And then there's another defamation case that they tried to settle as well. So, but then it's as if you have the money to be able to pay for legal services, then you are going to get the right representation to be able to get out of the hook. Until then you have to face the full rigors of the law, whether it being fair or unfair. Because no one is speaking for you, then you are languishing in jail.
Because no one is speaking for you. You are languishing in jail. And so that's lawyer Edu Dako Esquire that we are talking to. He's bringing all these informations to us. A lot of us don't know the law, and as a matter of fact, the interpretation. Now, lawyer, you made mention of education. I know we're going to wrap up in about 5 minutes. You make mention of education about the law. Why is it so difficult for some of us, even those who are very educated, cannot find this thing anywhere? Is there a website for a lawyers association for us to go and then read what is the law? What can you do? I mean, the group of lawyers or whatever association you have do in order for people to go and then read the law, because a lot of people think they should have some basic idea, knowledge about it. And so if you have anything for us to go and look at into some of these laws and their discretion, then I think it's going to help the public as well. And then finally, the last question is that with all these charges on Evangelist Pat, on her way out, is she going to sign any document to prove of good behavior or something? Do you have any of such a thing if somebody is being released from a jail?
All right, thank you so much. So, on the first question regarding education,
Right.
there's no single platform where you can go and say that you are going to get legal education about all the laws in Ghana and everything that we do. There are pockets of organizations that are making use of digital studies. So there's a platform called the Dennis Law. It encompasses all the cases at the Supreme Court that has been determined that has served as judicial precedent and all the various acts. But that one you have to pay to subscribe to it. There's one that is also called Gali. It is also a research center, online research platform where you can get all the laws of Ghana, the various acts and the various statutes that we have, that you can get bits and pieces of knowledge from. But that is not conclusive. The truth of the matter is that you can even read the law and the letter of the law and will not get the spirit of the law. You not get understanding of what exactly and how to even apply it. That is a technical area that is specialized for lawyers to train and to be able to make use of. So by education, what I mean is that platforms like your own and many other media platforms that we speak on should not only be interested in the outcome of matters, but should be interested in the process, so that when the matter is before a court or when the matter starts, we follow through. I have done some cases that at the initial stages there will be a lot of media interest and engagement. For example, there's a case, a very high profile case that I did in relation to some rape case at KNUST those times. I think about 3 or 4 years ago, when about 6 students raped, is alleged to have raped another student. And at the beginning, when the matter started, I was representing those 6 students, and I maintained the position from day one that it wasn't raping as much as they all slept with the girl. It was a consensual sex, and the conclusion that we came to. But before then, at the initial stages, almost every time you have the media houses being particularly interested and engaged in the matter. But just when the people were remanded, and then all the sweetness of the story died off, nobody cared to even follow up again. So at a point, they were like, oh, so was it going to get to a point where the media will not even be interested in this matter? So I'm sure a lot of people don't even know that those people were discharged from the court, because then there was no interest in the prosecution, especially looking at the fact that the young lady consented to that sexual act, which was our defense right from the beginning. So by education, I mean that we should always encourage our practitioners. Some of us are available. We have been availing ourselves for so many years and giving a lot of education when called upon. But it's also a very busy practice where you are taking money from clients and representing them and ensuring that indeed they are receiving justice. And you will not have all the time to be sitting on platforms and radio stations and TV stations to educate. But because there's a lot of us, and some of us have availed ourselves, we can be assisting one way or the other. And then the NCC, National Center for Civic Education, they have an obligation, and the Information Services Department, all those people have an obligation to teach about basic rights, about the right to bail, the right to counsel, the right to the practice of your religion, but knowing the boundaries that you cannot go beyond, and all of that. So those organizations, who we finance with our resources, our taxes, should also be out there educating people on those basic things, and then also make it a part of our curriculum in the various basic schools, so that even before you get to the tertiary institution, you have a fair idea, the basic principles of the law and understanding of the law, so that some minor things will not be used against you, and then you can also know your rights and how to defend same. And when someone abuses yours as well, you can also know the right channels to proceed. And then on the last point, if you may remind me again, the last question was in
That
relation to.
to when you're being released, is there any documentation for you to sign
Yes,
to
yes,
be
there's a
of a good
documentation that you have to sign.
behavior? Yeah.
Yes, yes, that depends on the nature of the sentencing or the conviction. So there's a matter that I did that the person was put on probation because the person was a juvenile. So the person was put on probation and then was made to make a bond, sign a bond to the effect that if I commit any such offense or any offense that is punishable by law, I may be punished in accordance with the law and be given a double sentencing because you have committed an offense before and you are supposed to be of good behavior. So that is done. But in this particular situation, like that of AGRADAA, I'm not sure of any consequential orders to the effect that sign a bond of good behavior. But you see, when you look at what happened at the circuit court at the beginning, her 15 years was informed by the fact that she had already been convicted in a separate offense years before. That has got to do with fraud and those things. And that one was a fine. But the fine is a conviction. So Agrada is an ex-convict. Even before this sentencing, she was an ex-convict. So that was taken into consideration. That is how come the judge gave 15 years. It's part of the reasons a judge will give you more years, because you are known to the law and you have not repented. So then you will get more. But I think that
think we are missing lawyer for me to know the network. The network situation is giving him a little hard time, but like we always say, like we're discussing here, I believe you've heard enough for all of us to understand the reason why she will be released in about 12 months. And so we recommend or we ask all of you, whatever you are, to take very good care of yourself and make sure you don't fall into trouble, because sometimes the legal backing, so the legal representation is very expensive. And so I wanted to ask him that, but since his network, we are trying to see if we can get him back on it. I'm taking this also to let all of us be aware that whatever you do here in our system here, yeah, you are not different from the race who have been convicted. But if the law gets hold of you, then you see that the law actually works. And most of us thinks the law is just it just there, it doesn't work, but until you get yourself into trouble. So we've have some few informations from lawyer Edu Daku Esquad, and I think we will bring all our conversations here. And those of you who liked it, and go share it. Share it. This is a very good information. From 15 years to a year needs some few clarification. And since we've got that one already, I think it's a good thing for all of us to embark on it. Just be of a good behavior wherever you are. Don't get yourself into the law, because when the law gets you, that is where you think somebody doesn't like you or hate you. So it doesn't work like that. Please be careful and stay away from trouble. I've said it too many times, but it is for our own good. Thank you from wherever you're watching us. Like it, subscribe on YouTube, all the social media handles, this Data K. Thank all of you for showing up and then supporting this for a good cause. We pass all this information to all our listeners across the globe to make sure we are also part of being the good citizen and not spectators. So whatever you are saying, witnessing, testifying indicates that we are doing the best we can in order to pass all this information to you. So dedicate, once again, we love you. Be a good citizen. Be a good person. Don't get yourself into the law. But in case of anything pops out, you're going to reach out back to lawyer Edu Daku again. Data K. Thank you. See you in a few. The whole book.